Court does call the cases of the people versus Shelby Miller.
Good morning, Your Honor. Assistant Public Defender Chinazi Carey, on behalf of Miss Shelby Miller.
Well. Long time no see.
Yes, Your Honor. It's a pleasure to be here.
Yeah, we'll see. All right.
Your Honor, today is a date and time set for probable cause conference in Ms. Miller's matter. We are still in negotiations with the people. Yes.
Miller, could you state your name, please? I'm sorry.
That's okay.
Shelby Miller. I go by male pronouns though, please.
Okay.
Yeah, thank
you. I'll note that in the file. If I make a mistake, it's not on purpose. Okay.
Thank you.
Thank you. Okay, what are we doing on this?
Your Honor, we are asking for an adjournment. I will just be asking for 2 weeks. I did have an opportunity to speak with Shelby, and we have a plan set forward, so I just need to speak with the people about it.
Without objection, October 24th, 2024, and you probably don't know about a green sheet, but I'm going to need one, please.
Sure thing.
Bond will continue. Thank you, sir. Court does call the case, people versus Rebecca Valentine.
That's Lonnie for the people. Assistant Public Defender Chinazi Carey, on behalf of Rebecca Valentine, Your Honor.
Valentine, can you state your name, please?
Yes, and I did say I want to represent myself, so I don't know where that communication was failed. Rebecca Valentine, I don't wish to have an attorney represent me.
Okay, you want to represent yourself in this matter?
Yes.
Okay, so what do you want to do today if that were the case?
What are my options?
Pardon?
What are my options?
I can't apprise you of that, ma'am. I can't give you legal advice.
Probably just adjourn it for 2 weeks and they could let me know what they want to do next.
Have you spoken to the public defender or an attorney at all, ma'am?
Yes, she was very inconvenient, not communicated with me, and I let her know I would like to represent myself. I think that you're allowed to tell me like reasonable information, and then I can make a reasonable choice about my own representation. Is that not my right?
Well, thank you for letting me know what my job is, but that's not how it works.
You're welcome, but I would think you should know this already.
October 24th, 2024, 9 a.m.
Sounds good.
I'll consider that a waiver of her time requirements. Bond continue. Thank you.
You're welcome.
Should I put anything on the record?
What'd you say?
I guess it would be fair. For the record, Your Honor, I did try and reach out to Ms. Valentine.
How'd that go?
It didn't go very well, Your Honor.
Oh, I'm just asking. I don't know. You don't have to answer me. That would be privileged. Did it go as well as my conversation just now?
You actually heard her voice. So
Oh, okay. That must be part of my charm. All right. Okay, what are we doing?
I apologize, Your Honor. Today is the time set for a probable cause conference in this matter. I know we've been adjourning this matter out to see if we could get Ms. Atkins into the recovery court at 14B. We would like to ask for an adjournment today. Ms. Atkins was requesting 2 weeks, but I know that that's not going to be enough time for 14B to complete the assessment.
That's correct.
That's my understanding as well, Your Honor, the 14B paperwork, I think the court has it for the recovery court now to.
I've signed it.
Yeah, so I don't know that 2 weeks is a realistic turnaround. We have screening done.
Want the 24th or the 31st?
Let's do the 24th, Your Honor, please.
Probable cause conference, October 24th, 2024.
If we could, Your Honor, we'd like to address bond.
Go ahead.
Your Honor, we're
It
asking.
needs to be a different argument than what I've heard before, but go ahead.
Okay. I apologize in advance. I do not know what information the court already has in regards to Ms. Atkins. Ms. Atkins would like the court to know that she has completed the Don Farm in Jail program. She is a mother of two children. She has a 19-year-old and a 13-year-old, Your Honor. Right now, there's an issue because they were living with her at the time of her arrest. Their lease is about to end and they do not have anywhere to go, Your Honor. Ms. Atkins is really hoping that she would be able to be home to at least facilitate housing and other necessities for the children.
I don't need a response. Go ahead.
There's currently an open CPS case pending her 13-year-old daughter. She has a father, but the father has not been involved in her life since they were divorced back in 2019. He's in Michigan, but we don't know where he is. CPS has been trying to locate him to see a possible placement for the 13-year-old, but right now there's no other place that the 13-year-old would be able to go. She's been working hard on her sobriety. We do understand that the court has concerns about her ability to stay sober while she's out of custody, but I think with the information and the knowledge that she's been able to gain from the program she just completed in custody, that would at least allow her to get enough of a stable footing while 14B does the intake for her to see if we can get her into other programs that may be suitable for her specific needs.
All right. I don't need a response. Those are basically, in essence, the things that I've heard before. However, I understand why they're being brought to the court's attention again. It's the same ruling. Bond motion for bond reduction is denied. Bond will continue. Thank you. Court calls case People versus Wayne Eagleston. Your name, sir?
Wayne Eggleston.
All right, I have before me a plea form that indicates the defendant is going to be pleading guilty to the charge of attempted unlawful use of a motor vehicle, 1 year offense. Upon his successful plea to that charge, count one would be dismissed. I guess that's SA is sentence agreement.
That's correct, Your Honor.
Sentence agreement to 1 year in jail, which this court cannot bind the sentencing judge to, although I understand it's your agreement, and no delayed or deferred. Again, this court is not binding the sentencing judge to that.
Thank you.
That's correct, Your Honor.
Let's have him sworn.
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Wayne Eggleston.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted unlawful use of a motor vehicle.
Correct.
All right, that's a misdemeanor punishable by up to 1 year incarceration and a $750 fine plus court costs, as well as license suspensions by the Secretary of State. You understand that?
Yes.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
Correct.
All right. Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct, sir?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
All right. Which one?
Probation.
All right. Were you on probation at the time of this offense?
No.
You sure? You don't know.
It's the same offense in a different county. Same day, same offense. Different charge.
All right. So you're on probation in another county
For this.
that happened after or for this, but the events occurred in a different county.
Yep.
Okay. I don't think he did.
Another different charge, different county, same case.
Same possession of the same vehicle in a different county.
Yep, same vehicle, same accident. Yep, different county.
All right,
Add another charge to it. Yep.
all right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced?
No,
You're doing this voluntarily
correct.
of your own free will
Yes.
because you believe that you are indeed guilty?
Yes.
July 23rd, 2023, at the location of 9575 Austin Road, Bridgewater Township, Washington County, State of Michigan. What'd you do that makes you think that you're guilty?
I used one of the work trucks and got in an accident.
Did you have permission to take that truck? For that purpose?
Not to get in an accident, no.
Well, did you have permission to take the truck at all?
Depending on the circumstance, but no, let's say no. Let's go with no.
You had permission to take the truck for work purposes, correct?
Yes.
And you took the truck for non-work purposes?
Correct. There
And
you
you
go.
didn't have permission, is that correct?
Correct.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Whoa, not the.
Oh, he thinks it's funny that I'm, it's,
I don't think anything's funny about it, sir. I'm just telling you, you weren't answering my question.
I used the truck for non-work purposes, so I didn't have permission at the time that I took it. Correct.
I'm sad. Defense is satisfied. Thank you, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
October 29th at 9 a.m. before Judge Simpson.
October 29th, 2024, 9 a.m. before Judge Fresh Hour. Bond will continue. Thank you.
Thank you,
Thank
Your Honor.
Court calls case People versus James Johnson.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Johnson, Your Honor. Mr. Johnson is approaching the podium.
State your name. James Johnson. Good morning, sir.
Your Honor, this is the time for a probable cause conference. We have reached out to the people in regards some video. And I've communicated with Ms. Lundy, and she says she's informed me that it is in the process. We'd ask the court to adjourn this briefly so that I can obtain that video.
How much time will it take the people to get that to them?
We can do 2 weeks, I think, will be.
Okay.
I know we want to get that done.
Probable cause conference will be adjourned until October 24th, 2024.
Thank you, Your Honor.
Bond will continue. Thank you.
Actually, Your Honor, could I ask the court to set a nominal bond in this matter? Right now, his bond is personal recognizance.
Okay.
We live in a
Except
markedly
I
different.
tried to, hold on. I tried to do that the last time. Mr. Johnson told me he didn't want me to do that and that it wasn't his first rodeo.
Yes, Your
I
Honor.
remember it real clear. So now you want me to set a bond?
Yes, Your Honor, please.
You want me to do that, Mr.?
Yeah, something low.
Huh?
Yeah, send me something low. What's up, Alan?
Set bond in this case is 1,000. I'll give it 10% privilege on it.
And that day was October 12th, correct, Your Honor?
Sure.
Thank you, Your Honor.
He just wanted to tell me no. That's why he said it the last time. Yeah, I know.
Assistant Public Defender Jay Bellinger on behalf of Robin Finney, whom I don't believe is here, Your Honor. I've made every attempt to call her, left her voicemail, text message, email, sent carrier pigeon, no response. I am also aware of the failure to appear community corrections alleged violation. So I haven't heard from her. I could request adjournment if you would grant one. That'd be great, but I understand you're probably not going to do that.
Bench warrant,
Okay.
25,000 cash surety. That warrant will issue immediately.
Hey, if we don't ask, we're never going to get it right.
That's right. Court calls case people versus Dondre Roberts.
Excellent. People.
Citizen Public Defender in the Apple appearing on behalf of who's approaching now. You state your name for the record. Hold up over here.
DeAndre Robertson.
Thank you. Your Honor, the court should receive a plea form in this matter.
Yes, I have a plea form that indicates that he's going to plead guilty to attempted resisting and obstructing the 1-year offense. Upon the successful plea to that charge, count 1 would be dismissed. And the people agree to immediate sentencing, but I don't know that I do. Why is that?
I've been in communication with the police officers who were involved in this. They're approving of immediate sentencing. The defendant has a hold out of the city of Texas. And I believe wishes to go and address that as soon as possible. The deputies were understanding of that.
That's correct, Your Honor. That's our basis for requesting the time served immediate sentence. He has waived extradition, so as soon as this case is resolved, he will proceed to Texas.
Seven sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
DeAndre Robertson. All right, sir, it is this court's understanding that you're going to be pleading guilty to the charge of attempted resisting and obstructing. That's a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that? Yes, sir. You understand that? Well, I will be your sentencing judge. So understanding all of that, you still wish to plead guilty? Yes, sir. And to that charge, how do you plead? I plead guilty, sir. Now, you understand that by pleading guilty, you will not have a trial of any kind? Yes, sir. You signed an advice of rights form, is that correct? Yes, sir. Any question regarding any of those rights? No, sir. Look at paragraph 5. There's a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Oh, man.
Let the judge know.
No, sir.
He has no further questions.
Okay. You understand you're giving up those rights? Yes, sir. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? Out in Texas, yes. Pardon? Out in Texas. Which one? That's probation. Probation? Were you on probation in Texas at the time of this offense? Yes. Okay. I do have to advise you that this plea in this case could be a violation of that probation that you have. Yes, sir. And that court, if it does consider it a violation, could sentence you to the maximum allowable under that other charge. You understand that? No, sir. You don't understand that? You said it's a violation. If it's considered a violation, that court could sentence you to the maximum allowable under that other charge that you're on probation for. You understand that? Yeah. Understanding that, you still wish to plead to this charge? Yes, sir. I'm sorry, I didn't hear you. Yes, sir. All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? They promised me that the deal with this case, it'll be dropped to a misdemeanor. And then I'll be sent back to Texas. Okay, don't know about the sent back to Texas part, but it has been reduced to a misdemeanor. That's what you're pleading to. All right. Anything else anybody promised you? No? Basically, all I heard was being transferred once I signed for a misdemeanor.
In the only promise that was made is that the felony would be reduced to a misdemeanor, correct? Which was stated on the record. Yes. No other promises have been made to you to get you to plead guilty.
No, ma'am.
today? Thank you.
Has anybody threatened you or coerced you in any way to get you to plead?
No, ma'am. No, sir.
You're doing this voluntarily,
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty?
Yes, sir.
September 29, 2024. Location of Sweet Road and Holmes Road, Ypsilanti Township, Washtenaw County, State of Michigan. Did you come into contact with deputies from the Washtenaw County Sheriff's Office?
Yes.
What happened?
Your Honor, may I have one here?
Yes, please.
Thank you. On that date and time, Mr. Roberson, did the officers attempt to pull you over? Did they conduct a traffic stop and you saw their lights behind you?
Yeah, there was, it was white at first. You know, they put white on the license plate so they can read it and get the information off the license plate. And then,
And Mr. Roberson, based on the information from the plates, they conducted a traffic stop.
yes, sir.
Okay. And you knew that they were officers conducting a traffic stop?
No, all I thought was they was just reading the license plate.
Okay. But at some point they activated their overhead lights and in their lawful duty were attempting to stop you in your vehicle, correct?
Yes.
Okay. And you ultimately did stop your vehicle, correct?
Yes.
Okay. And then you proceeded to get out of the vehicle and run,
Yes, ma'am.
correct? And you did not comply with their commands?
Yes, ma'am.
Defense is satisfied.
Counsel. Madam Prosecutor.
People are satisfied, thank you.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Anything you want to say before I impose sentence?
Your Honor, I would ask the court to impose minimum fines and costs. As the court is aware, Mr. Roberson is going to proceed to Texas to handle his matter there. So I'd ask the court to take that.
How long's he been locked up here?
He has been in for 12 days, Your Honor.
Is there anything you want to say before I impose sentence?
I just want to apologize for my actions. And that I should have complied with lawful and I should have stopped. And I just want to apologize, Your Honor.
All right.
And that's it.
Fines and costs of state minimums of $125. All over 365 days in jail. Credit 12 days. The balance is suspended. All right.
Thank you, Your Honor.
Thank you. Good luck to you, sir.
Thank you, sir.
Court does call the case of the people versus Scott Foster.
I'm coming, Your Honor. Senator J. Bellinger, on behalf of Mr. Foster, who appears to my right. Mr. Foster, can you please state your name for the record?
Scott Foster.
Thank you. I have before me a plea form that indicates that he's going to plead guilty to the charge of retail fraud, 2nd degree, the 1-year offense. Upon his successful plea to that charge, retail fraud, 1st degree, would be dismissed. There is a sentence agreement that's between the parties because I'm not agreeing to that. To no upfront jail, no delayed or deferred.
There's a correct statement of the agreement that you have.
That's a correct recitation, Your Honor.
May I have him sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yeah.
State your name.
Scott Foster.
All right, sir, it is this court to understand you're going to plead guilty to the charge of retail fraud in the 2nd degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that?
Yes.
Yes, I do.
And understanding all that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, correct?
Correct.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
You understand that?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will? And because you believe that you are indeed guilty of this offense?
Yes.
July 2nd, 2023, at the location of 7,000 East Michigan Avenue in Washington County, State of Michigan, Pittsfield Township, Washington County, State of Michigan. What'd you do at the Walmart that makes you think that you're guilty?
Your Honor, I was at the self-checkout and I put items in the cart that were not scanned.
You skip scanned.
Correct.
Is that right? Store was open to the public at the time?
Yes.
You didn't have anybody's permission to do that, did you?
No.
And these items that you skip scanned, these were items that were offered for sale by Walmart?
Yes, Your Honor.
And did you skip scan an amount in excess of $200?
Yes, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be
November 13th at 9 a.m.
November 13th, 2024, 9 a.m. That is before me. Bond will continue. On your way out, stop. You'll see them on the left-hand side. Stop down there with probation. Okay.
Thank you. Appreciate you.
Thank you.
If you have any questions, okay? All right.
Court calls the case People versus Brian Haggard.
Mike Jennings, public defender on behalf of Mr. Haggard, who's approaching as well, Judge.
Your name, sir?
Brian Haggard, Your Honor.
Thank you. Nope.
Maybe I could give, we could exchange.
Exchange the two things.
Your office right now. It
All
does include positive tests for cocaine. And it is a case that I am requesting an adjournment. It came in as an OWI investigation. I wanted to charge it immediately, given this person's substantial substance abuse and the violence given to the police officer, given that it's an RNO case. Since then, his blood has come back, and I am ready to move forward with an OWI third charge against him. But I'll need to authorize that and then have it resworn to, and then if we could address the bond violation as well. I'm sending this in, but summarize September 5th, benzodiazepine and THC and buprenorphine positive. November 11th missed. November 12th, those same 3 substances, as well as cocaine, despite not earlier. November 20th, positive for those 2 substances as well as cocaine.
November.
Yeah, I'm not reckoning we got there yet.
I'm sorry, I'm meaning to say September. I'm so sorry.
Thank you.
September 5th, September 11th, September 12th. I apologize.
Got it. It's okay.
September 20th, buprenorphine, cocaine, THC. September 24th, missed. September 28th, buprenorphine, THC. October 3rd, buprenorphine, THC. Sorry for that.
Yes. All right. It's in my car.
12, cocaine positive is confirmed by Redwood toxicology. And that is.
Okay. You said cocaine was confirmed?
Yes.
Your Honor, while we don't, since there's another case coming, we don't, it doesn't make sense to hold the exam on the RNO than to set the other one. So I wouldn't object to the adjournment. Actually, I filled out the green form, so I guess I don't. In terms of the bond violation, Your Honor, I believe there's been some tests as of late. He does, Mr. Haggard does have a prescription for the buprenorphine, the Suboxone that we can provide to. They should have.
Okay, so what about the cocaine?
Your Honor, he denies that. We've certainly he sent that out to the Redwood. Had community corrections send that out to the Redwood lab for verification. I believe it did come back. I believe there has been tests since then, these tests were in September. We're now almost in double digits in October. I'd ask the court to adjourn this matter and keep the bond violation pending to allow him to demonstrate to the court that he can comply with the court's testing, not just its directives, but its mandates that he not test positive for these substances.
This time, I'm going to adjourn this out. I'm only going to adjourn it out 2 weeks. He's going to have some other type of plan in effect or some other type of thing. But at this time, I'm going to revoke the defendant's bond. Defendant's remanded to the Washtenaw County District. Case. Oh, yes. Good. Thank you. Court calls the case. People versus Joseph DeLiz.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. DeLeach, who is present via Zoom, Judge.
Sir, can you unmute and state your name? Are you trying?
Are you able to ask someone, sir?
We're trying to force him, but Miss Ahmood, good morning. Now, sometimes while we wait, sometimes you just have family hanging around. And sometimes when you have family hanging around, they're sometimes doing things that they probably shouldn't be doing.
I already know.
Right next to you, but it's okay. She already knows?
Yeah.
Okay.
Yeah, great. Picture right here.
Not so much. No. Is he? So we can't force him? It's not. Okay. Let me just pass it briefly and
Thank you, Your Honor.
see. Oh, no. I thought somebody was coming in new now. Okay. We'll call you back up in a moment as soon as we can get you unmuted, Mr. DeLeese.